Good morning and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today. We are going to pick up on Vallow Daybell. She has a hearing later today. She does have a hearing a little bit later today. But before we do that, we're going to show a hearing that happened last week. Seems like my audio is okay.
It is. It was muted.
Okay, audio is okay. All right, so there's a live hearing for Lori a little bit later today. But before we do that, we're going to pick up on one that happened last week as we kind of get prepared for Lori's trial, which is coming up. Jury selection is at the end of this month. With them expecting for the trial to actually begin April 6th or 7th. So for those that are not familiar with Lori, I'll just do a quick overview, just a few minutes because we could spend hours talking about her, but she's already been found guilty of conspiring to being involved with her two children. One was her biological daughter, Tylee, and then the other one was her adopted son, JJ. So this happened in, that was 2020? Let me just double check. So 2019, right? In September 2019, that's when those two children were last seen. And then their bodies, unfortunately, were found, or I don't know if you want to say unfortunately, but their bodies were found on Chad Daybell's property. Now, Chad had been married to another woman who also ended up mysteriously deleted, and then Lori and Chad ended up getting married. So they finally were brought to justice. Both of them were found guilty. But then before all of that, Lori's fourth husband, Charles, was shot by Lori's brother, Alex Cox. So now she was extradited from Idaho to Arizona, where she now is facing charges for the 2019 shooting of of Charles Vallow. So Alex pled not guilty because of self-defense, because he said Charles came at him with a baseball bat, hit him in the back of the head, so he shot him. Now Lori had supposedly wasn't there. She went to Burger King while this was all kind of going on. It was a morning, so she went over to Burger King to get some food, but then she came back and she was telling the police, stories and whatnot. So she's already been convicted of her two children's deaths. Now she's on the hook for her fourth husband's shooting. And the thing that makes this interesting, aside from all of that, is that she's going to go pro se. So that's one reason why we are very, very interested in covering this. So I would like just to say hello to everybody. Love My Grands is with us today. Pammy, good morning to you. Mel Stiller, MEG, hello. Baka, Widespread Panic, thank you for joining us. Fala, hello, good morning to you. Let's see, Dreama, how are you? Thank you for joining us. Hellcat, good morning. Cajun Bayou Queen, good to see you. Shirley Roth, hello. And let's see. Only Fan, good morning, sausages. Nice. With her fashionable orange jumpsuit, yes. Nan R, hello. Drunky the Bear, good morning. Happy Taco Tuesday. Yes. Awesome. All right, so thank you for joining us. We're, let's just get to it. So this hearing happened last week. It happened on the 11th, so last Tuesday. So this hearing happened last Tuesday. So we're going to get to this, and then the live one is going to kick in at 11:15 our time. So it's 10 o'clock, yeah. So this should take us to the live hearing. So let's come over here. Let's go ahead and play. This is from last week, and this will just give you a taste of where Lori, what we can expect to see. Lori's going to be pro se, so we're actually looking forward to checking her out.
CR 2022-001242.
Attorney Kay, on behalf of the state, for the record, the next of kin in the 2021 and the victim in the 2022 are appearing virtually.
Good morning, Your Honor. Pamela Hicks, advisory counsel on behalf of Ms. Daybell, and Robert Abernathy is out of the office today.
Okay. You want to announce?
Lori Daybell, on
Thank
behalf
you.
of myself.
All right, we have a number of things to get through this morning. The first thing I want to address is there's been multiple media requests. I don't know if there's a representative of the questionnaires would be emailed to the parties. That would give the parties the 28th, 29th, 30th, and 31st to go through those answers. We would meet on the morning of the 1st, discuss who needs to be let go based on those answers. Also on the morning of the 1st, a number of walk-in jurors that for whatever reason don't fill out the questionnaire in advance would come in to the jury room, the jury assembly room that morning and fill out the questionnaire. So that morning we'd also deal with those walk-in answers as best we can. Oh, that's right. I back up. The initial answers for the remote, we're going to meet on the 31st. Let those people go. Whoever we don't let go will be told to report on the afternoon of the 1st. On the afternoon of the 1st, we'll be dealing with the walk-ins that come in the morning of the 1st. And the people that we haven't let go the afternoon of the 1st, that will be in person voir dire as needed. If we need to, which I anticipate we probably will, we'll do another 200 jurors on the 2nd. And if need be, we have another 100 jurors on the 3rd.
That next set of 200, that wouldn't be a remote question?
They don't have a capability to do it remote, so we may have to, what'll happen is on the 1st, all those people, after they give their answers, will be randomized. The list will be re-randomized. As we proceed through the 2nd, those people get added onto the bottom of the list. So as soon as we get 12 jurors that qualify, that everyone's happy with, that don't have issues, plus probably 3 or 4 alternates. So as soon as we get to about 15 or 16, we're pretty much done with jury selection. So we don't have to necessarily question all 200 of those people. We can do panels of 20 or something like that. I anticipate losing quite a large number of people just based on prior media coverage and people already having some sort of opinion about the case. I normally wouldn't include a defendant's name in the e-questionnaire that goes out remotely, but on this case I'm inclined to, just because that's what we want to know. We want to know if people have heard about the defendant and whether or not they've heard about, or if they've formed an opinion about her or this case prior to that. Does anyone have an issue with that, State?
No, Your Honor, I think that that's a good idea. That's going to be at least one of the initial reasons to strike a lot of jurors.
My only issue with it, Your Honor, is that it could be bad both ways, right? If you put the name in there, if you don't put the name in there. It's been my experience that people will say they haven't heard when they know who that really is, and there's people that will want to be on this jury just for this purpose.
Well,
it's going to be complicated.
all the research indicates that these e-questionnaires, people are more likely to give honest, candid answers than if they're in a group of people and they feel sort of that peer pressure of what's a good answer and what's a bad answer. Your name's going to come up sooner or later, so I would prefer to just get it out in front of the potential jurors to begin with. My e-questionnaire is going to be fairly basic. It's going to focus on qualifications, the charges, the witnesses, and then obviously whether they have an opinion about you or this case. For the people that make it past that level, we'll question them more thoroughly in person.
And like you were saying, as far as group kind of voir dire, in my experience, we went through 1,900 jurors in my last trial, so it would be good to do individual voir dire if we can, than group voir dire, because they learn things just in the voir dire, and it disqualifies a lot of jurors.
I'm not opposed to that, but that's going to be sort of a day of play it by ear sort of situation, whether
Sure.
we do small panels or just go a single person. If we go single person, our jury selection could extend into the next week. But if we're able to seat a jury, I would expect opening statements on April 7th, somewhere around there. Does the state indicated, I have it, there was just one day in April that you wanted to go a half day?
Correct, Your Honor. The 24th.
All right. When can you file some sort of pretrial statement that sets forth all your potential witnesses and a statement of the facts?
Probably by Thursday.
All right. Does the state anticipate any presentation of autopsy photos or crime scene photos? In other words, I'm trying to gauge, I would usually put in a question about jurors may be required to view evidence that shows wounds or that sort of thing. Is there anyone that's unwilling to look at this type of evidence?
Yes, Your Honor. We will have both, obviously, with self-defense, trajectory, and those injuries are very relevant.
Okay, so I will include a question about that type of evidence. Sometimes jurors don't want to look at that type of evidence, so. All right, any questions or concerns about our jury selection, the proposed trial dates from the state?
No, Your Honor.
Just so I have it clear, Your Honor, we're going to start on the 31st with jury selection? Is that correct?
We'll be meeting on the 31st,
Okay.
and then actual dealing with in-person jurors on the 1st, 2nd, 3rd.
Okay.
Robert and I.
Let me ask advisory council, are there any dates that advisory council would need to be dark?
I am fine for April. I didn't hear back from Robert. I would think.
Please let us know, because in that e-questionnaire, I'm going to put in a proposed schedule. I don't know that I'm going to screen for a full 6 weeks based on the state's anticipated presentation, maybe 5 weeks. So let us know the schedule into the first week or two of May.
As soon as I get an answer from him, I'll email your judicial assistant.
All right.
And one more time, Your Honor, so the remote question is going out on March 24th. All answers have to be back by the 27th, so we will get them on the 27th, or,
You'll either get them late the 27th or first thing the 28th.
Okay.
In the morning, late in the morning of the 27th.
Oh, okay.
okay.
So I'll put it-
You should get them some point on the 27th.
Just so we can plan, because it sounds like we'll just go out to Estrella and go through these.
Yeah, they're closing it at like 8 a.m. on the 27th.
You'll have to have a internet connection.
Yeah,
out
we
there.
can use
Okay.
our laptops out there,
Okay.
because you want to be ready to discuss everything on March 31st.
Yeah, and if the parties have an obvious, there's some jurors that are going to be obvious that need to be let go. If you're ready for that, that's always helpful. I know it's a little bit more difficult with pro per defendant in consulting like that. All right, let me get to.
So we'll come out on Friday and go through the questionnaire. Okay.
We don't get any questions on that.
All right, the defendant had filed two separate motions for specific discovery. The first dealt with communication between the assigned deputy county attorney and law enforcement agencies. I've read and the second one was, well, let's deal with the first one. I've read the response from the state. Basically, your response is you have disclosed all those communications. There are no other communications.
Correct, Your Honor.
All right. So let me ask the defendant.
Yeah, we received 6 email communications, and they were in a short time frame, not the full time frame. And it seems to me that in the last email ends in kind of a question that was probably answered, and then there's like no more communication. So it doesn't make sense that there's no more. We asked for all of them if they could be provided to us. We don't understand why they're not being provided to us, and what the state is possibly hiding at this point, and they can't just turn it over so that we can go through them. It's been, long over a month since we filed that motion, so we would just like them to please turn over whatever they have left.
All right, and I'll ask the deputy county attorney. I imagine some communications are by phone, so in other words, we're not captured.
Correct, Your Honor.
All right, based on the state's avowal, I don't know, I can't tell them to turn over something they say they don't have, so I'll find that the state, based on their avowal, and officers of the court have complied with the request. The second one is a little more, I wanted to get clarification on. That was defendant's requests for video interviews, but it seemed like based on the state's response that there was some confusion about what was a interview recorded in an interrogation room situation versus a body cam. Did the state's response provide clarification to you?
No. So the body cams were turned over, and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one, to be turned over to the defense.
All right, so do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed? And you said the 2-hour interrogation that Gilbert released.
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
And is that in an interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed. Is an interview of, it is
And you're saying you don't have it?
defendant, her daughter, and another.
And you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one, and the full entire, my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in discovery.
That's what I'm trying to clarify. So did the state disclose not a body cam, but an interrogation from up in the corner of a room vantage point?
We disclosed a lot. Let me see if I can find out. We did. Yes, my paralegal is present here as well, and she has advised that we did. Your Honor, we disclosed over.
Can your
Where is
paralegal
it?
provide a Bates number or something so that maybe the defense just has overlooked it?
Let me see if I can find the actual
Maybe the discovery notice.
discovery letter.
Okay.
Your Honor, all we do have is the 4 body cam. We can ask again and see if they have a overall.
Are you getting this? Have you seen this, or someone told you that there's this video?
My mitigator showed me part of that video, yes, with my previous team. That's how I know about it, otherwise I wouldn't know about it. And she said, do you know this is online? I didn't have any idea.
And you're sure it's the Gilbert PD on that date?
Correct.
All right, I'll ask the state to follow up with Gilbert on that.
We will, Your Honor.
There, if that is out there, obviously it should have been disclosed. All right, remind me to follow up on that next time we are together. Next, I have a motion limine, 2 motions in limine, one regarding Alex Cox statements and one regarding Tylee Ryan's statements. All right, so let me ask the defendant, generally any hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. The state is referencing what are definitely out-of-court statements. Obviously, there's some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you think, let's first talk about Alex Cox. How do you think the statements fit into your, either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing, and obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex Cox that I do not think falls under hearsay.
Why not?
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what he said was true?
I can't say whether another person says that it's true or not, but I'm saying what he said and what my daughter said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So, yes, I think they're for that purpose. But I also think that Alex's statements also have a lot of the exceptions apply. 803, 804, there's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think they apply to?
Specifically, his statements made on body cam to police in the driveway, specifically his...
I don't know what the statements are, so that's what I'm asking. What specific statements do you think are allowed to come in under the rules of evidence?
I think under 8031, the present sense impression is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So, isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying
Yes,
something
prior.
that he's, okay,
Correct,
so it's not a
prior.
present sense impression.
Okay.
What else?
Then I think it falls under 8032, excited utterance. He was under the stress of the whole situation when he made those statements.
What was his demeanor when he made those statements?
Upset.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Well, immediately to some people means 2 seconds, to other people it means 30 minutes. Tell me what immediately means to you.
As soon as the police arrived.
I don't know did they arrive 30 minutes after the incident? 10 minutes, an hour?
I was not there. I do not know what time they arrived.
All right. So you're asserting excited utterance. Some of these statements come in. What else?
8033, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Any others?
Yes. 8035B, the recorded recollection. I know that in the state's reply to my response, they did not think that 805 applied because A, B, and C, but I did not see an and after A, so my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803B, the recorded recollection of his police interview and the body cam footage applies under that exception.
All right. Generally, 8035 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state to respond. We're just talking about the Alex Cox statements.
Your Honor,
Maybe I should start with, does the state intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty we will not be admitting his interview by police that was done at after 10 o'clock in the morning. We don't.
Are you referencing what time he was interviewed versus the time of the incident?
Let me say it this way. So the state has laid out in its motion the timeline. So that is actually in our motion. We show that when
8:30 a.m.
is
roughly.
when the 911 call was made. So we have soon after that the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
So you may or may not be attempting to introduce statements at or around the time that the police responded?
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right. But I guess, is the state intending on introducing any statements of Tylee?
No, Your Honor. Tylee made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station, again, after 10 in the morning.
All right. So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition with the same thing, her state of mind, then being scared. And also 8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview saying she's scared to tell the police that she's the one that brought in the bat. So state of mind and the statement against interest both apply to Tylee's
All right.
police interview.
All right. Anything else? Does the state want to be heard further on that?
Your Honor, the only further thing I think that the state will bring in is that obviously the defendant has been found guilty of killing both Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later try to bring in their statements for their benefit. So in addition to none of her statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be improper for her to be allowed to bring them in under that theory.
In other words, there's been a judicial finding that the reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
All right. All right. The court is, on a preliminary basis, precluding references to Tylee Ryan's statements, any statement made by Tylee Ryan. If there's some reason where a door might be open to any of those statements coming in, the defendant's requested to make a request outside the presence of the jury regarding that, and we'll deal with that outside the presence of the jury. On Alex Cox, I think that's probably going to be more of a statement by statement basis, but I'm skeptical of any statements coming in hours after the initial police response. I think we'll deal with what statements may or may not come in when the police first arrived on scene and or the 911 at the time that they're attempted to be introduced. All right. I also received yesterday state's notice of disclosure and request for disclosure. Did you get a copy of that?
No.
You haven't seen that yet?
No.
I'm sorry, the
State's notice of disclosure and request for disclosure. I didn't realize it was actually filed in January, so you should have seen that. I misspoke when I said I got it yesterday. It was filed January 16th. Have you seen that?
I'm looking it up.
What are we?
Dates
I
disclosure.
think the court may have ruled on that one, Your Honor.
Well, I don't think I ruled on, at the very end, you're requesting she submit to fingerprints, palm print, footprint?
Oh, that's, okay. I think that was prior, yes, significantly. So that would be to tie her to any of her.
Is that for other conviction purposes?
Correct, yes.
All right. And when did you want to do that?
What is that about?
If we are going to be here on the 18th, we can take them then.
I don't know that we need to be here on the 18th.
And obviously, I was unaware we were going to set this because we set it
Right.
just recently, so. I don't know if we can keep that on just to take that.
Okay, what about the state, you requested copies of any recorded statements made during interviews conducted outside of your presence. Is there any of those, were there any interviews conducted by you or your team? Of
So
any,
far?
were there any interviews conducted of any witnesses out by you or your team that you're aware of?
So far, not that I'm aware of.
All right. Do you plan on calling any experts to testify?
We do plan on calling one expert.
Who's that? Has it been disclosed to the state?
We are, yes, we're working on that today as an addendum to the
Who's that?
witness list that, Lonnie Dworkin.
All right. That's your investigator?
No, my investigator, Jeff White.
Oh.
That's the expert.
What kind of expert is Lonnie Dworkin?
Phone and digital.
I think I remember his name. Are you aware of that?
No, Your Honor.
All right. Expert reports and disclosures are due 30 days before trial generally under the rules. So if you're planning on using that witness, you need to get that disclosed right away, and I may have to take that up depending on what the state's position is. But at this
Your Honor,
point,
that-
it's technically late.
May be another reason to be here on the 18th. Obviously, if that's disclosed this week, we can potentially address that issue on the 18th.
All right. Let me ask the defendant, do you have a position on the taking of prints and photographs? Generally, identification type things are permitted over any defendant objections. So do you have a record you want to make on that?
Not really.
All right. I don't see any
For
reason
what
why.
purpose? I don't understand.
In the event that you're convicted, it may be used to prove other convictions. That reminds me, is the state planning on proceeding in the second trial regardless of what happens in the first trial?
I believe so, yes, Your Honor.
And how much time would you need between the conclusion of the first trial and the start of the second trial?
Your Honor, I would say at least 30 days since we do need to actually subpoena out-of-state witnesses for the second trial.
I'm wondering if it wouldn't benefit everyone to go ahead and set that, a provisional second trial date now.
That's fine, Your Honor.
May 11th is still my last day.
Is that second trial,
Right.
how long do you think it would take the state to
Probably
present?
about 3 weeks as well.
Similar?
I'm not gonna argue. Your Honor, I'd like to remind the court that the last day is May 11th. Oh yeah, there's that rule.
Well, I'll probably exclude some time based on the fact that you can't do two trials at once.
The state could combine the trials and do two trials at once, but they don't want to do two trials at once, so it really violates my speedy trial rights if they do not give me a speedy trial by May 11th for both cases. Not to mention that they did combine all the discovery into one case. They didn't give me two different separate discoveries for two different cases, which would be much more convenient considering the voluminous amount of discovery that they piled onto us.
Does the state want to combine both cases?
Your Honor, if the court gave us a little time to work it out and the defendant wants to join them, I mean, obviously,
I don't know that.
the normal defense attorney, and I don't mean that in any way, normally they would be
Derogatory?
severed.
Severed because you don't want one jury to know about the other
Correct.
two separate charges and have a harmful rub-off effect of the evidence in one case affecting the evidence in another case.
Correct, Your Honor. That's why they were filed separately. But if the defendant wants them together, the state would have to request this be pushed back slightly so that we could then get all the witnesses for that trial together, since they were not subpoenaed for this trial. But if that's what the defendant wants to join them, and she understands that prejudice and that she's then going to be waiving that prejudice with that, then the state is certainly willing to do that. But we would then have to request to have that trial, or this trial date, moved back to allow us to get the other witnesses lined up.
That's not what I was saying to combine them. I'm just saying give me my second trial by May 11th. So
Right.
the court can figure that out.
All right, well, I'm going to waive some time on that second trial over the defendant's objection. Primarily, again, the defendant can't try both cases at the same time. Secondly, I'm not sure how much actual prejudice there is with a time violation in the sense that you wouldn't be released from custody anyway. And thirdly, the rule for time violations under Rule 8, I think it's 8.6 is that any violation should be a dismissal without prejudice unless there's an actual prejudice shown, in which case the state could just refile the charge. Regardless, I think some time is warranted to be excluded because primarily you can't try two cases at once. What if we set a start date for May 12th? I realize that's could potentially be a quick turnaround, but again, I don't think this case is going to take 6 weeks.
Your Honor,
We can adjust that as necessary.
I, again, am going to ask for a longer time. I believe this will go through the beginning of May, and to have the state try to get those witnesses lined up and subpoenaed while in trial, I don't believe is.
Well, if I push it out any further, the parties need to be aware that I won't be trying the case. I don't think I would be anyway. I'm rotating at the end of June. And given some of the trainings I have to attend in June, I don't think we could get it done.
Well, both parties could send out subpoenas now for that second date for May 12th, correct?
Well, that's assuming we're done by about May 1st, probably, in this case, the first case.
And then, Your Honor, I did indicate that the state needs to be dark in May, the 21st, 22nd, and 23rd.
You said 21, 22, 23.
Correct.
In May.
And I would need to be dark the 19th, 20th, and 21st as well, so.
So given that we would be dark that entire week anyways, it really doesn't make a whole lot of sense to.
All right, let me sorry to interrupt. Let me speak with the criminal presiding judge about scheduling the second trial. We can discuss it on the 18th. Let's keep the 18th, but let's move it to later in the morning. Actually, let's move it up. All we're going to do is discuss a couple matters, and then there's no reason for the fingerprinting and stuff to be broadcast or on video, so I'll prohibit that from being recorded or otherwise broadcast. So have your person here. Let's do that at 8:15 a.m. on March 18th. And then we'll also discuss whether the defense is disclosing Lonnie Dworkin as a witness and whether or not he has a expert report prepared and disclosed at that time. I will have the questionnaire for you by then, so you can review it. Anything else we need to discuss that I've forgotten about from the state's perspective?
Your Honor, I showed two other motions that the defense filed that I did not see rulings on by the court. They were both motions to dismiss. One of them only related to the 2022 case, I think. No, I'm sorry. Both of them related to both.
What's the filing date?
January 14th for one of them was an 8.2 speedy trial one. And February 4th, which was an extradition rule 8.3.
February 4th. Okay, so the motion to dismiss CR 2022-001242 for lack of speedy trial I ruled on January 24th.
Okay.
That minute entry was filed January 24th, and then the motion...
That just seemed to get
Was that the motion to dismiss CR 2021 and 001704 and the other for violation of Speedy Trial Act?
Correct.
That was ruled on February 25th, so last week,
Okay.
a week ago. Anything else from the state?
There, Your Honor.
Anything else from the defendant?
Yes, Your Honor, I have one kind of housekeeping matter that I wanted to ask you about. I know that MCSO has some security restraints, the things that I have to wear during trial, and
I meant to
I wanted to ask about that as far as, am I going to be able to stand at the podium to talk to witnesses, to question my witnesses and to cross-examine, or am I going to be able to move about with the leg thing and the shock vest and all that?
You're going to stick to your table and you can go to the podium. Okay. When you're giving your opening statement and closing argument, you'll stay by the podium.
Okay.
And if you need to hand a witness an exhibit, your advisory counsel will do that.
Okay. Or my paralegal can do that.
Is your paralegal going to be present here, designated as your? I guess they can be present. I'd prefer advisory counsel to be the one that approaches witnesses if you need to hand an exhibit or something like that.
Okay, so I'm going to be standing there, and if she's sitting here, she's going to come get something from me and go walk it over to the witness and then come back?
Correct.
Just the logistics of it?
And there'll be a table or a cart here that'll have all the exhibits on it within reach of the podium. So.
Okay.
Anything else?
Your Honor, do you use case lines for exhibits?
No.
Thank you.
I think they're still working out the bugs on that. So.
Do we need to have our exhibits in place?
All right, we'll see you at 8:15 on March 18.
Clerk so she can mark them.
Be at recess on this matter.
It's usually like a day or two.
All rise.
So I feel like we're going to hear a lot of hot mic moments, a lot of whispering. Okay, so that was from last week, and you heard them mention March 18th. So that's why we wanted to show that, just to kind of give you, I don't know, just kind of get you caught up on where Lori stands before we start this next one, which is coming up. Let me see here. All right, so it's going to be about another, let me see, 30 minutes or so. I'll go over what we just heard. Oh, another hour. So when is this starting? 11:30. Okay, so we got about another hour to go. All right. Boy, we didn't time that one right. I was hoping we could just go right into the other one. All right, let me go through what we heard. So the judge talks about he's received multiple media requests. He talked about jurors coming in. So I missed how many were going to be on the first group, but that would be the first, April 1st, right? Yeah, April 1st. And then another set of 200 jurors on the second, and then another 100 on the third. So he says, once we get to about 15 or 16, we will be done with jury selection. And then Lori says, it's been my experience that people will say what they can to get on the jury. I'm paraphrasing, but she basically said, it's been my experience. That's something that you don't want as a non-lawyer or non-paralegal. You don't want to say it's been my experience, because that shows that you've been through the process already, which we know she has. Then she goes on to say, well, we went through 119 in my last trial, and I suggest that we do individual voir dires, not group voir dires. So the judge kind of talked about, the benefits of both. He thinks opening statements will begin April 7th. The 24th will be a half day. There are some dark days in there too. I didn't catch all of them, but there are going to be some dark days, so they're not going to go just straight through. They anticipate it'll take 5 to 6 weeks. Now, I think originally the state thought it would take about 3 weeks, right? 3 or 4 weeks, but now with Lori being pro se, they're kicking in another. So it's going to be it'll be a month. Yeah, more than a month. It'll be more than a month. Let's see. Let's see. So Lori contends that the state, the state says they have disclosed all information, but Lori's like, she doesn't understand why the state hasn't provided these emails and what they're hiding. So I'm really looking forward to her. I mean, this is going to be really a really interesting case. So the body cam was turned over. Lori says the body cams were turned over in increments, but she wants the full 2-hour interrogation to be turned over. And states like, those are body cams. They were turned over, so she's not sure what the defendant wants. But then Lori says there's a full interrogation that she found out online. It's herself, it's her daughter Tylee, and her and Melanie Gibb. Who is Melanie Gibb? Is that her? I forget. Let me look her up. I think that's her. Is she related? Former best friend. So it's just her. I thought that she said she was like related to her, but yeah, she's just her best friend. Melanie Gibb is her best friend. So apparently there was after Charles was shot by Alex, they did a full interview, which was from a vantage point of a camera, wherever a camera was, versus this body cam of people coming and going. So Lori says, they've only given me 4 12-minute videos and they're all mixed up. There's a full 2-hour one from the ceiling is available online, but I don't have it in discovery. So the state says, we disclosed a lot, and then her paralegal confirmed that it was turned over, but then the state says, well, all we have is the 4 body cams. We can go ask, they're going to ask the Gilbert Police Department for the overall complete one. So Lori said, my previous team told me otherwise. I wouldn't have known about it. Yeah, she's already snarky, and not in a good way. The judge says, if it is out there, obviously it should be disclosed. And Lori's like, She whispers under her breath, So then they get to Charles and Tylee's statements. There was a motion in limine. So judge kind of describes, goes over the definition of hearsay and how it relates to this. The state is referencing out-of-court statements. Lori says, feels like the state is doing this blanketing thing instead of just a case by case. The Alex statement, we're not using it for the truth of the matter. She says, I can't say if another person says it's the truth. She knows just enough to be dangerous, that's for sure. Then she talks about the 8031 excited utterance, which I was like, ooh, excited utterance, because that's a channel name. And that's the first time I actually heard it used in a courtroom setting. That's why I was all excited. She's like, because he was under stress. I just got hit by a baseball bat by my brother-in-law. So she doesn't know what time the police arrived because she wasn't there. I think she was at Burger King at that point in time. But she says, excited utterance shows Alex was his state of mind because he was scared. But then the state says they don't plan on showing Alex's interview after 10. So he called 911 at 8:30, and then they show the body cam from that, but they're not going to show this interrogation. So state has laid out their timeline in their motion. They're only going to show the 8:30. Well, the body cam from the 911 call. They're not going to show him being interviewed afterwards, I guess. The state is not bringing Tylee's statement at the scene because she just gave biographical information. She didn't really give any information that would provide, useful, I guess. Now, because the defendant has been found guilty of deleting a witness, she can't bring her statement in for this trial. Oh my gosh! So because Tylee was deleted and Lori was found guilty of that of that at previous trial, she can't now bring in a witness's statement because that witness is no longer with us, and no longer with us because of the defendant. This is interesting. Lori didn't get a copy of notice for disclosure that was filed January 16th. Judge wasn't sure why she didn't get that. Lori does plan on calling an expert. She says, we're working on that today. Lonnie Durkin or something like that. And judge is like, well, who is that? And is that your expert? She's like, no, Jeff White is my expert, but we're also planning on bringing in this Lonnie gentleman, and this is a phone and digital expert. So not quite sure where that's going to go, but then the state wasn't aware of that. So then the judge is like, well, usually discoveries due 30 days, or expert witnesses discoveries due 30 days before a trial. That's usually under the rule. You need to get that disclosure right away, or it's because it's technically late, and they're going to address that today. That's one of the reasons why they're having a hearing today, is they're going to address that. So we're going to hear about that in 45 minutes or so. Then she's talked about, she whispers, May 11th, still my last day. So I can't wait. We're going to hear so many hot mics and so much stuff. I just can't wait. She whispers that to her standby counsel. The state anticipates a 3-week trial for the second trial. Now the second trial is, I'll get to that. So Lori says, I'd like to remind the court that May 11th is my last day. The state could, and then she's like, the state could combine the two trials if they want, but they don't want to, and it violates my right to a speedy trial. And then the state's like, well, with the normal defense attorney, and she's like, no offense, and Lori's like, derogatory. She would understand the prejudice of the jury hearing, one trial. If you combine these two trials, the jury would hear one, and it would prejudice them, one way or the other. So then the lawyer's like, well, the court can just figure that out. She doesn't want to combine, but she wants her second trial to start May 11th. So now the second one is her conspiring to have her niece's ex-husband shot at and or deleted. So so this one is the first one is for her for her fourth husband who was shot by her brother. Her brother was claiming self-defense. Charles was shot. Now her brother has passed away too, so he can no longer testify. So that's the first trial. That's what she's up against right now. Then the second trial is Alex took a shot, or somebody took a shot. We think, whatever, the general public thinks it was Alex that took a shot at her niece's ex-husband. So that's what the two trials. That's why she's on trial down in Arizona. Let's see. Let's see. The first case is expected to be done by May 1st. I'll be happy if it's done by then. The judge asks, "Is anything else?" And the lawyer says, "Yes, I have some housekeeping to do. Am I able to stand at the podium or move about?" So she's worried about, she's got handcuffs, shock vest, button, whatever, shock belt. Judge says you're able to stick to your table and you can go to the podium. If you need to hand any evidence, you can give it to your standby. And Lori, of course, says, or my paralegal. And he's like, well, he prefers it to be her standby counsel. So, all right. So that was the serious issues. So we're not sure what's going on, but seems like all right. What are you guys talking about? Therapist, and she's calling Brandon as a witness. She's a nut. Absolutely. Brett says, Fala, crazy. That would make me really suspicious of what the police are up to. Let's see. Fala says, I watched the documentary this weekend where the police refused to go over records and the prosecution actually had to file a motion against the police. Wow, that's bonkers. Brett says, the prosecution is responsible to turn over whatever the police have, saying we don't have it, the police do, doesn't fly. Widespread panic. Maybe she should contact previous counsel to see if they've got it. Little Miss says, Melanie is the one who introduced her to Goober. That would be Chad, I'm assuming. Brett says, if there is interrogation video that hasn't been turned over yet, that would annoy me. Ah, there you are, Suber. Good to see you. Thank you for joining us. Appreciate it. Dreama, this will definitely be a cray-cray show. Yeah, we're looking forward to it. Let me see what we can find. Let's see what else we can find about Miss Daybell. Oh, let's check this out. Why not? All right. Well, we have time to kill. Let's check it out.
And then I'll so just make it easier so you don't have to. Yeah, you got it? I'll be up from desk. So if you want to.
Yeah, Margaret's using the other one,
Okay.
so you'll be, Brendan's gonna monitor for him.
Okay, so just run out this way
Okay.
if there's anything, but if,
Perfect.
that's right.
Okay.
teachers, but in high school, they don't care. They're
They
like,
don't care.
you're not here, do the work, or don't. Like, they don't care.
Well, and I
So
think
horrible.
with high school, it's like, they're just pumping.
But when she was in elementary and junior high, all the teachers worked with her. They were nice about it. But by high school, there's so many kids that just don't care. And I was like, just take it. You're so smart. Let's just take it, see if you pass it. She passed it. Like,
And got a really good score.
and, yeah, she passed it with like college ready in every category the first time.
Well, and now she can do what she wants, so.
Exactly.
She's better off that way. Okay. I know Laura's your first name, right? L-A-U-R?
L-O-R-I.
Okay. And then what's your last name?
Vallow. V-A-L-L-O-W.
And your date of birth? And your phone number? And you live at the house, right? Okay. Okay, I know this sounds silly, but it's probably the easiest way to start, is just to tell me what happened. And then, so you can start what makes the most sense to you, and we'll just work our way through, and I'm going to ask you a bunch of questions just to kind of clarify.
Sure.
So I know you talked to the initial patrol officer.
And he just got information. He didn't say
Okay.
anything.
So yeah, if you can just kind of tell me kind of what happened. It sounds like some of this may have started last night or something along those lines. So
Right.
start where you think it makes the most sense.
Okay, so,
I told you, it's a crazy question.
Well, so we moved into this house 3 weeks ago because he offered to get me a house here where all my family is. So we
Okay.
were in Houston. And so he's like, we had decided to separate or whatever. So he's like, well, I'll pay for a house for you and for JJ and whatever, because he's all about JJ. He's never about Tylee, but he's all about JJ. Because we adopted him together. He's his great nephew. We adopted him as a baby. And so we adopted him as a baby, and so we've been raising him together. And he travels all the time for business, so he's used to just going back and forth. So he's always gone like Monday through Friday. So he came when we first moved in and brought me stuff from Houston, like a U-Haul, and then he hasn't been back. But it's all these threats on my phone all the time, you know, like whatever, all these things. And then he told me...
What kind of threats?
Just... You'd have to read them to see, but he's always mad at me, right?
Okay.
And he doesn't want a divorce, but I don't like him and don't want to deal with him, so that's just how it is. Like, so we married for 14 years, we've dealt with it for 14 years, of him being horrible to her. Like, he gets in huge fights with her, a lot of things. But anyway, so he said, I'm coming Wednesday night. All of a sudden, I want to see JJ. And I told him, I said, I will never keep JJ from you. You can come see whenever you want to. Come take him to school, whatever. Like, I'm not going to do that.
So when you initially moved, he had said he was going to buy you a house. So you moved here with your...
Yeah, he was going to rent us a house.
And so you moved...
All my family lives here. So we lived here for a long time.
Okay.
And then he moved us to Houston.
Okay.
And we were there with my son. He was out of school. He didn't have any of his, like, services, his DDD, his anything. He, like, ripped him out of school and said, we're moving.
Okay.
And I didn't go with him at first. And he took him. And I let him take him, and I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him and let him see what I've been doing for the past 7 years, because men need to do that. You know, I have 5 kids, I have grown kids, I have grandkids. Like, okay, you're going to threaten me that you're not going to let me see my child without supervised visitation? Okay, do it for 30 days and see how long it lasts. You're begging me to come pick him up.
Yeah.
Which he did. She's like, come back, and whatever. So I moved in with them to Houston for the family, you know, and Tylee went with me. We drove to Houston from here and left all our family and all his support, all my son's support, like his cousins, everything. And we were there, and I enrolled him in school there. I tried to start all his services, and it takes forever.
Yeah.
You know, it takes so long to get that done.
There's no easy transferring.
There's no easy transfer.
You start from the
State to
beginning.
state, it's a totally new thing.
Yeah.
And he didn't do any of it in those 30 days. So he just had gone without services, without even applying. And I'm like, do you even realize? Because he didn't ever do it in the first place. I did it. Long story. I'll keep it short. He hasn't been here in a couple weeks since we moved in. He came He was very nasty when he was there, but he travels for business. So he went back to the Houston house, and he's like, I'm coming on Wednesday night, and I'm going to come pick up JJ and take him to school Thursday, pick him up Thursday, take him Friday, whatever. And I said, Casey wanted to come to the house, and I said, you can't come stay at this house because you can't get along with Tylee. She's a minor, she has to live here.
Yeah.
So, because he gets in huge fights up there.
Okay.
And she hates him. And so I'm like, you can't stay at the house, so I will book you a hotel, because he stays in hotels all the time because he travels for business, and the business pays for it, right? So I said, I will book you a hotel nearby.
What does he do?
He works with teachers and their retirement plans, but he goes to them at their school. He mostly works in California, no matter where we live. And we lived in Hawaii, he'd work in California, he'd work in Texas. He has like books of business in different areas. And so he just goes wherever. It kind of just gives him freedom that he doesn't have to stay home every day and take care of special needs child. It's like an excuse, right? So I've done that myself for the past 7 years anyway. And I was a single mom before I married him with my 2 kids. And he had 2 kids. We got married, tried to make a family. You know how it goes. Anyway, so he said he was coming last night. I said, well, you can't stay at this house because you can't get along with Tylee, and I'll get you a hotel and you can come play with JJ. But he goes to school all day. I got him back into his school. His services, I met with the DDD yesterday, and they finally are getting his services back, but we're paying $125 a day to have him back in school because he's so out of his routine. He's been a nightmare on the floor, kicking stuff, hitting stuff, walls. Like, he just ripped him out of his life. So, anyway, just how he is, because he only thinks about himself. So he says, coming to get JJ, and JJ's like, I don't want Dad, because he knows Dad took him away, so he was freaking out, right? So I didn't tell him he was even coming, like, Dad's going to come take you to school or anything. So he didn't bother me last night, which I was surprised. I was expecting kind of an ambush for him to kind of, like, come over or be just mean. And say, it's my house, I'm on the lease, I'm going to stay here, kind of thing. Because that's kind of his macho attitude. And so he came this morning. I was getting JJ ready.
So he got in last night, but he wasn't at the house last night.
Yeah, I didn't hear from him, except for he texted me and said, I'll be there at 7:30 to pick up JJ. And I was like, okay, that was good, because I didn't hear from him. And then he came over in the morning, and he's like banging on the door. I'm like, oh great, here we go, you know. And I was just gonna be nice. I was just gonna be nice as possible, and I had JJ stuff all ready for school. And so,
do you remember about what time he got there?
He said he'd be there at 7:30, but it was more like 7:40ish or 7:35. I don't know. But I remember thinking, looking at the clock, and he wasn't there at 7:30, and he's usually Mr. On time. Yes. So I was like, okay. And then JJ was like, oh, Dad. And then he was like, Mommy, and like ran to me and was like holding me. He's like, you're not taking me to school. And I was like, it's okay, Dad, can just drive you to school. It's not a big deal. You know, just trying to make it whatever. Calm. Yeah, calm. And then he was just being real smirky and real like jerky, you know, to me. And I was like ignoring him, whatever. And so he was like,
your brother lives there with you?
No. Okay. He had stayed with me last night because I was worried he was going to come over and cause trouble with me. And just wanted someone else there, like my brother there, because I trust my brother. And it's been a long story. Like, I had to go live at my brother's when he took JJ, and, you know, he's just been difficult. So, anyway. So I got JJ's stuff ready, and he was like, well, and he's like this about timing. He's like, I'm leaving in 20 minutes, because it's like 15 minutes to the school, and like you can't get there early, they don't open the gates until 8:20 or something like that. And I said, well, why don't you just go now? I don't want him in the house. I'm like, why don't you just go now and take him to Burger King, because that's what he likes for breakfast, and he's very particular about food. Like, he wanted chicken fries for breakfast and a Sprite. Like, and I just get what he wants, because if you don't get what he wants, then it's like on the floor screaming, dragging him into school. Like, and he's big and he's heavy, and it's hard for me to handle. But anyway, so I said just go, and so he said okay. So I gave him a backpack. He got in the car. This is his MO, right? He always leaves something in the house and comes back. He never leaves the first time. I always expect my husband to come back into the house, right? So I guess he had left his phone on the counter.
So he initially left with the backpack and with JJ?
And so he put them in the car, in the driveway, and then he came back in, right? So I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, giving me my phone, and I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's
plotting something against me. Like, I'm like, why are you even here? Like, what did you come here for, you know? He's been talking to my other brother, and my brother came into town at the same time last night, and I haven't talked to my brother in a while, my other brother, and I was like, and so he was texting him on the phone when he first got to my house, and I'm like, why are you texting Adam? Like, do you even talk to him? Like, my other brother. And, you know, he's been telling me all these texts, like, you're going down, blah, 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 blah. He's blaming me for our marriage breaking up, and my niece getting divorced, and my friend getting divorced. He said, I'm a destroyer of families, because I want everybody to get divorced. I'm like, what would my motivation be for people getting divorced? So I could babysit the kids more? Like, why would I have any control over what people do?
Yeah.
So, it's just very odd. But anyway, he goes nuts. He's gone nuts on us a lot of times. Tyler and I have had to leave with JJ over the years, probably 5 times, and just stay in a hotel for 2 days, because he goes nuts. Like, you don't know what's going to set him off, like, whatever. And she's mad at me for always, like, going back. But we had JJ, and he's special needs, and it's really hard. Like, it's even hard to take care of it by yourself.
So when you say he goes nuts, that can mean a lot of different things.
Right.
So, goes nuts like yelling and screaming?
Yeah,
goes
yelling
nuts
and
like
screaming,
breaking
like,
things?
yes.
Goes nuts like physical violence?
He's never really, besides, like, grabbing us and pushing us, but not, like, punching us or something. But with Tylee, he has gotten physical before. And with my grown son.
Like physical how?
Like, got into a physical fist fight with my son when he was 16.
Okay.
And he came after Tylee 2 times in Hawaii.
Okay.
And, like, went like he was going to hit her, but then I got in between them. Right.
How old was she when that happened?
Probably 13 and 14.
Okay. So this morning he comes back in and...
He comes back in, I wouldn't give him his phone. He was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there, and he was screaming at me. And I was kind of walking around the house with it, so he couldn't get it. He's like reaching for it and stuff like that. And so Tylee came out of her room upset, and she had a bat. And she told him to leave her mother alone, like, right? So she was really, whatever, and he's screaming at her, don't you hit me with that bat, blah, 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 blah. And then my brother heard all the commotion, because he was in there in bed, and so he came out into the main room, and I guess whatever.
What's your brother's name?
Alex.
Alex, okay.
And then he just started, he was screaming, and he was super upset, and whatever, and he's yelling at Tylee, don't you hit me with that bat, and blah, blah, blah. And so Tylee, I guess, I don't know if she swung at him or what, but he, like, grabbed the bat from Tylee and then went to, like, hit Tylee with the bat. It was, and I was right there, and they were right there, and my brother grabbed him from behind, like, just to stop him from hitting Tylee.
You go like this, like he grabbed him, like...
Yeah, from behind, like, just kind of to pull him back. And then they got into the thing, and he's hitting him with the bat, and they're on the ground, like, grappling around or whatever. And then, I mean, it was all quickly.
And he hit your brother with the bat while they were grappling and stuff?
Yeah, yes, he was hitting him with the bat, like swinging the bat, you know, back and forth, and they were kind of like on the ground, and I was like freaking out trying to go around, knowing JJ was in the car, right? And so then he got up and he had the bat like this towards me, and I was going around the other side to try to just get out of his range where he couldn't hit me. And then I had told Tylee, because she was on the ground, because after he took the bat from her, she fell back. And so I told her, I was like, go get in the car with JJ. Like, I don't want JJ coming in to the house, and I wanted her out of the way. I wanted the kids out of the way, whatever this fight was going to be. And then,
do you remember what your husband or your brother were saying or yelling during all of this? If they were at all?
Just kind of, get off me, ow, or whatever, you know, whatever. They were like, don't talk to my niece about whatever. Like, it was, I don't remember specifics, but they were kind of both, they were kind of in the heat of it. I don't think there was much
Many
words
words.
that I remember.
So Tylee goes outside,
Yeah, she was outside,
and then what happened?
then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me at the back, yelling at me to give him his phone still, because I had it in my hand. It was all really quickly, and then when I went around kind of in the circle, then my brother was there.
When you said when you were going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards, almost in one arm.
Like he was swinging it backwards? He would have done like
Like he would have swung it backwards at me, not frontwards.
Okay, yeah.
He was a professional baseball player.
Okay.
So it wasn't a good idea for Tyler to get out of that.
Probably not the.
I mean, he played semi-pro when he was young. But, yeah, and then I was kind of turned around, and we were all right there in that room, except for the kids had been outside by that time, and I heard the gunshot. And
so you heard the shot? Did you actually see the shot, or did you just hear it?
I had gone around to the kitchen to get away from him, and so back around. So I don't know if you went in the house.
I didn't, so I'm a little bit of a disadvantage.
Yeah, so I didn't see the shot. I heard it, and then I came back around and I saw that he was on the ground.
Okay.
And was freaking out.
Yeah.
And so I was just freaking out, and it just went into Mama. I'm like, I've got to go to get JJ to school. I've got to get to the kids. I just felt like I got to get to the kids. And so I just went outside and to see if they were in there okay. I didn't want them coming back in the house when all that was going on. And got JJ in the car, and he was trying to come in. And Tylee was like looking at me with like the crazy eyes, like what just happened. And I told her to get in the car and we're going to take JJ to school. And I just left.
When you came back in and you saw him on the ground, where was your brother? Did you see him where he was at?
Yeah, he was right in front of him.
Okay.
Like it all happened very quickly. I feel like I was there because I was right there, and like a second later, like I just went around the kitchen to get away from him.
Did your brother say anything to you at all? Do you remember?
No, we were both just in shock.
Okay.
Like it was just I didn't say anything. I went out with the kids just to check on them first, and I was going to come back in maybe, but I didn't. I was like, I just have to get him to school and call the police and come back, whatever.
Did anybody say did you or your brother say anything at some point about calling the police or calling 911? Do you remember?
Yeah, he called me.
Okay.
And he said, are you taking JJ to school? And I said, yeah, we need to call the police. And he said, okay.
Okay. So he called you when you didn't come back inside, basically?
Right.
Okay.
Because I was like in the car for a minute, and then I was like, what do I do? And I didn't want JJ to go inside, and I didn't know what to do, and Tylee was freaking out. I was trying to get them away from the scene.
Understandable. And you may not know this, so, because I know you heard the shot, do you know at what point your brother had the gun? Do you know if he had it when they got in their first fight, or did he have to go get it, or do you know that at all?
I don't know.
Okay.
I don't know.
And do you remember if you ever heard your brother?
I didn't see him ever leave the room.
Okay.
So it was so fast. All that was so fast. Like him on the ground, rolling around, and I'm screaming. And
this probably happened in a couple seconds.
Yeah, I mean, it was like super fast.
And I don't know if you know this or not, does your brother normally carry a gun? Like, I carry a gun everywhere I go.
Right. Like, I know he's a gun person. Like, he has guns and things.
Okay.
He's good with guns.
Did you know that he had one with him?
No.
When he came over?
No, but I wouldn't be surprised if he did. Because he's very, very professional with guns.
Proficient, professional. Responsible is usually a good word.
Right, but responsible with guns.
And then, do you remember if at any time, So you were trying to get away from him,
Right.
and you heard the shot. Prior to the shot, do you remember at any point hearing your husband or your brother saying anything to either of them?
No.
So my second very ridiculous question is there anything else that I didn't ask about or anything that we didn't cover that you think is important? I always ask that just because I wasn't there, and so we're going through something that happened a super small amount of time.
Yes. Can I
So,
step back?
yeah, go for it.
Just thinking. Just that, he was just so angry, like super scary.
Did you
You know how you take your phone away from like a 16-year-old and they freak out? Like their world disintegrates. Like I've taken my phone away from a 16-year-old boy before, and he like, he's like wanted to kill himself because like they cannot function. That's how it was. It was like, is something on his phone that he does not want me to see, that he was like freaking out, like to the point where I thought he would hit me in the back of the head to get the phone.
Okay. So you thought, and I don't want to put words in your mouth, but you thought it was possible that he was going to hurt you.
Absolutely, he was going to hurt me and Tylee.
Okay.
Not JJ, he would never hurt JJ.
Okay.
And he hurt my brother. Like, he was going like ballistic about, it was bad.
Okay. I'm going to go talk to her real quick.
Okay.
And then if, obviously, we'll be here for a little bit, hopefully not too much longer. But if you think of anything, or there's anything that kind of pops in your head, or something else that we didn't cover, obviously. So I'm going to go talk to her for just a little bit, and then I'll kind of come back and check with you, and then we'll kind of go from there. So I know my partner's talking to your brother over in one of the other interview rooms. So we're going to just try to get as much done as we can and go from there.
Okay.
Okay. And then, is there anybody that you need to call or anything, or you want to wait a little bit?
I don't know what I would say.
And wait a little bit, we'll see.
Yeah. I don't know what I would say.
And if you want to, you can think about it. So we do have victim services that work within the police department. They're right over here. They're not cops, they're civilians. And they do, Jessica, who is out there with the fire department, so they're kind of our crisis response. They come right away. So our victim services that work in the department are kind of more long-term type support systems. So they're just a really good resource because they do a lot of stuff with our families and things like that, and can help with support services and questions you might have.
She's been through so much.
So it might be a
I
good
just
idea.
can't stand for her to have to go through all this.
Yeah, it might be a good idea maybe before I take you guys back today, that I get one of them to come in and maybe sit and talk with you guys and see. And it's not something there's a bunch of stuff they can offer, but it's good to have a contact and like a name and a face and a phone number.
That'd be good.
That way maybe a couple days from now, a week from now, or if there's something going on or you think you need help with something, it may not be something that's necessarily up like me and my partner's alley, but it very much may be up theirs. So I'd like for you to meet one of them before we leave. That way, hopefully if there's something that they can help you and your daughter with, they can, or even JJ or whatever else.
Right. Yeah, exactly. I
Okay.
hadn't thought about him.
Yeah. So,
I mean, he's used to him not being there, but he wouldn't understand even if you told him,
right,
like, that somebody passed away. He doesn't understand
what that means. Well, I mean, it's hard at 7 to understand that anyways.
Right, that's true, but with him he just doesn't, which is probably better because he doesn't comprehend things, but I don't know, it's just, it's a lot to think about.
Yeah. So let me go find one of them, and then we'll make sure that you guys get to meet with them before you leave, because that might be something very helpful for you guys. And I'm going to go speak with your daughter for just a little bit, and we'll kind of go from there.
Okay.
Okay? And if you need anything, let me know, okay? Okay. I like your daughter a lot.
She's fun.
Yeah. So one of the victim services, Denise, is here. So I kind of told her just a little bit of what happened. So if you're good with it, I'm going to have her come over and I'm going to introduce her to you guys so you guys can talk for a little bit, which kind of works well too because I need to run over to where my partner's at and just talk to him a little bit. That way you guys will have a little bit, hopefully, extra support if you need it. So I'm going to go grab Denise real fast and then introduce you guys.
Okay.
Okay?
That'd be great.
So this is Denise.
Hi. Hi, sorry. That's funny. That's funny. I'm so
So she's gonna take you over to like a conference room so you guys can sit and talk and stuff. And then you can just, once you guys talk and kind of, you can decide if you're comfortable with Tylee coming in or whatever.
Okay, sure.
And then we'll
I just didn't want her to be left alone and
Yeah,
by herself.
yeah.
She's freaking out. Like,
so we keep kind of popping in and checking on her and
I
stuff.
just didn't want her to be alone too long.
Yeah.
We'll be as brief for as long as you want, okay? I'm here to try to, you got lots of choices when you talk, so we'll just get started and then then we'll go from there. Does that sound okay? All right, thanks.
All right. So that was the interview that Lori was talking about in last week's hearing, that she just has body cam footage of when the police officers come in. So she wants that full hearing, apparently. So we know it exists. We just saw it. She says she knows it exists because her team before now told her about it. So we know it exists. So, all right. So now we wait. So apparently there's a 30-minute delay, but Joe is saying that let's see, that she's in chambers. So if you guys don't know, Joe Schmo is there. Joe, are you actually there? I know you're there in the area, but are you actually in the courtroom right now? If you can, go ahead and let us know if you were actually in the courtroom. So Joe's saying apparently Lori is having a discussion with the judge back in his chambers before she comes out. Irish Amy, I asked how your St. Patrick's Day was. You say it was good, thanks. Although I did have to break up a Pushkin brawl. Which tracks? The Baker and Silverman showdown made it epic. Okay, so Joe, you are actually in the courtroom. Cool. Baker and Silverman showdown. Nice. Yeah, Joe, we're so glad that you're here and chatting. We appreciate it. Front row, awesome. Cool. right. Butterfly Dana, Lori likes to be in charge, but doesn't like taking responsibility for the wrong she does. Super Ball's intimidation tactics to get her chair back are impressive. Yeah, she's trying everything she can right now. I don't know. Therapist, intimidation tactics made me laugh. Fala says, "Hey Joe, is her shoulder showing? I'll cash app you to fix it." Widespread panic. You think he was part of the conspiracy to delete Charles and Brandon? Who's that, Alex or who? I missed that part. Hey, G Stewie, saying, "Hey guys, I'm in and out between working, but wanted to say hello." Hello, hello. Joe saying in the courtroom and Judge 2. All right, cool. Well, we're on a 30-minute delay, right? We're on a 30-minute delay. Yeah, the teddy bear, I know, right? Hope Case Unwinder. Hey guys, what's up? I'm in between hearings. Yep, we are waiting for Lori Vallow's hearing to start. So we just showed the one from last week, the 11th, and they talked about that they would have this hearing to go over some things. So here we are waiting to hear what... Hey, Joe, is the courtroom packed? How crowded is it? We know there's only 36 seats or so. So how crowded is it? Widespread panic. We're talking about the teddy bear in the interview room just being silly. I saw it too. Yeah, I saw that too. And wasn't there one with what's his name? Chad Hadelson's girlfriend. I forget her name right now, but I think she had like a stuffed animal too. They must. I guess that's kind of standard. I guess. All right, so Joe Schmo is in the courtroom. He's got a channel, so definitely we'll be talking to him a lot more. We're hopefully planning some really cool things with Joe, so we'll tell you guys all about that as things unveil themselves. But Joe Schmo is in the courtroom right now, so we're excited to hear from him. Hey, Joanne Jedi Platypus, how are you? Yes, Kel. Do my Kel walks. Good to see you. Thank you for joining us. Kat. Yes, Kat was her name. Was that her name? And Halderson, yes. What was his name? Chazzy boy. Yes, Chandler. What was her name though? Her name was Kat. Yeah. Kat was her name. Butterfly Dana says, "Thank you, Joe, for being in court." Give Joe Schmo some love. There's his Joe Schmo 88 is his YouTube channel. Should be starting in about 5 minutes. That's what my notification is showing. So we'll see if that actually is true or not. Nanar, I'm sure kiddos have to be questioned, so the bear is there, yep, to cuddle. Makes sense. I think Kat was holding on to it too, if I'm not mistaken. I think she was cuddling her, the support panda. It was Kat? Yeah. "88 means love and kisses." I did not know that. In what form? So about another 5 minutes or so, actually 4 minutes. 4 minutes to go to the next hearing. Nanar 73 means best wishes. What language are you talking about? Cat had a Pooh Bear. Little Miss. Butterfly Dana, I hope Lori lost some privileges for altering that off-the-shoulder prison clothing. Oh, amateur, Nanar amateur radio. All right, cool. I did not know that. Yes, Cat had the Pooh Bear. Cat had the Pooh Bear. Dale Earnhardt Jr. was 88. Joanne. Aaron, it's always a pleasure to be here with y'all, you fine folks. Thank you. Thank you, Joanne. And I always love saying your name. Joanne Jedi Platypus. Just rolls off the tongue. Irish Amy, oh man, don't get me started on that mendacious Pooh Bear. All right, so we got another few minutes here. Actually, let me come over here. Let me actually come over here to get, okay. Once the feed kicks in, I'll go over to us. Yep, about 2 minutes left or so. That's what they're saying. Oh, let me go grab my water. Be back. Baker needs a bear. Fala, you think Baker needs a bear? Therapist, asked the 8-Ball, is Lori going to succeed in her defense efforts? Trial TV Bot says, who thought that would be a good idea? No, that's a good girl. Donna Ulrich, yes, we are still doing Monica today. Yes, we are still doing Monica. She starts in about an hour, so we don't anticipate this going too long. If anything, we'll just pick up on Monica, whenever this is over. But yes, we are still doing Monica. There's no way we're not going to miss more Baker, trust me. We will definitely be doing Monica. All right. Get yourself sorted out there, kiddo. And right after this hearing, we'll go over to Monica. Brett asks 8-Ball, does Lori understand hearsay exceptions? Bot says, give me a break. Therapist, hey, Donna, Monica's after this loon. Please don't say doing Monica. Yes, we will be doing Monica after this. Redirect is already in place. Donna, don't worry, we'll get our Monica fixed soon. Therapist, says I am not doing Monica. So Kathy Rustin says the hearing started in real time at 11:25. You should see our feed around 11:55. All right, great. So we got another 20 minutes. Hey, 88 Keys, good to see you. Good morning, all. With Lori's exposed shoulder and tank top underneath, it seems to think she's Jennifer Beals from Flashdance. I'm waiting for her to jump up at some point and perform What a Feeling. Nice. Yeah, we were just talking about 88. All right, so according to Kathy Russin, the hearing started at 11:25, and the feed should kick in at 11:55. So we got a little bit of time to kill, no pun intended. So that will push our Monica a little bit, but not much. I mean, I don't anticipate this going more than an hour. So, so we have some time to kill. Let me see what else is there out there that we can watch. Let me think here. Well, we can read a little bit about Miss Daybell here. All right, so her biological daughter, Tylee, right? So she was last seen alive on September 8th of 2019. And then her adopted son, JJ, September 22nd of 2019. So it was then late. Oh, wait a minute. What is Aaron Tylee's? Oh, okay, yeah. Let's play this. How long is this? Aaron found something for us. Let's see. Oh, this is 17 minutes. Perfect. All right, so this is Tylee's. Let's listen to this while we wait because we have some time. Let's watch this. So this is Tylee's interview.
Hi. So you have to spell your name because we're all taking guesses on how to spell it. We're not sure.
Tylee.
Okay, I was right. And what's your last name?
Ryan, Ryan.
And your birthday? And then, do you have a phone?
Yeah.
What's your phone number? Okay. So I know this is going to kind of sound like kind of a silly question because it's super broad.
Okay.
But can you basically tell me what happened today? And you can start at whatever place makes sense for you to kind of start and explain. And I'll probably kind of ask you questions as we go a little bit.
Okay. So I woke up probably around like 7:50, I want to say, because I heard yelling from like right outside my door. And I don't even know where I heard, but I immediately like jumped up, and I have a baseball bat because when I was living at my uncle's by myself, I just wanted something to like feel safer, and I'm not old enough to get like pepper spray or anything, so I was like, okay, I'll get a baseball bat. So I have that.
So your bedroom, you said right outside your bedroom door, and I didn't go in the house, so I'm at a little bit of a disadvantage. So what is your bedroom door open to?
My bedroom door open, so the room that my uncle was staying in, the room that's kind of like the guest room, if my room's right here, that's right there.
Okay.
And then my little brother's room, and then kitchen's kind of back here, so it's like a little hallway, and then right here is kind of where everything happened.
Okay.
Like the big, you walk in and...
Like big great room, kind of living room?
Yeah, right now it just has mirrors up because my mom wanted a dance room.
Okay.
So, yeah.
Okay.
kind of unconventional, but.
Hey, whatever makes you happy. It's your guys' house, so.
Right, so yeah, I immediately just jumped up and I grabbed my baseball bat and I opened the door, and it was my stepdad, you know, outside the doorway, and then my uncle kind of in the doorway, and then I could hear my mom behind him, and he was just screaming at both of them, like, I don't even know what he was saying, because honestly I was just too like wired, I guess. So I told him to take a few steps back. I was like, you're too close, you need to step back. And he was like, don't tell me what to do. And I just kind of just stood there, and then my uncle kind of moved out of the way, and then my mom kind of went past him and into like the big room where everything happened, and so I walked with them, and then
So they were more in the hallway.
Yeah, they were at like the end of the hallway basically, and so my mom walked all the way around, and he kind of followed them, and I just kind of stood. My uncle was like right here, and then my stepdad right here, and then me and my mom were kind of right here. And I didn't do anything with the base, held it there, and he was getting really close to my mom, so I kind of stuck it out like between them. And they were both just yelling, and he was like, if you hit me with that baseball bat, you're going to go to jail. And I just kind of stood there with the baseball bat, and I didn't really say anything.
When you said they were yelling, who was yelling?
It was mostly my stepdad.
Okay.
Well, he was really the only one like yelling. My mom was kind of like responding, but I honestly couldn't tell you what they were saying. It was kind of just like all jumbled up in my head. And so I just kind of stuck the baseball bat out there, and then he just grabbed it and tried to take it. So I held on to the end, and then eventually I fell, and he kind of took it into his hands like he was going to do something with it, and that's when...
So when you fell, he ended up with the bat?
Yeah.
Okay.
And so I fell to the ground, and then my uncle kind of like, I saw him take a step back, so my uncle, I think, grabbed him and kind of took him back so he couldn't like do anything.
You saw your stepdad like take a step back?
Take a step back, because he was really close to begin with, and then and so my mom said to go with JJ, and so I ran out the door, and then I kind of just stood there with my little brother. He was in the front seat of the car, and so I just kind of opened the door and just stood there, and like he was trying to get out, and I was like, no, we have to stay in. And I was like, oh, like, I told him, like, do you want to go in the Jeep? And then he was like, no, and then I realized that my car was blocked in, so I couldn't anyways. I was like, okay, like, just stay here. And then eventually my mom came out, and then we left from there.
Okay.
Yeah.
Do you know what happened inside of the house? Has your mom kind of explained it all to you?
I just kind of asked her, like, because I heard a noise, which I know what it was now, but it sounded like, because I knew that the baseball bat was in there, it sounded like someone, like, took it and hit it really hard against the floor.
Okay.
And so I was kind of like, Al's okay, right? Because that's my uncle. So I just wanted to make sure that, like, my stepdad didn't do anything to my uncle and stuff. And so she was like, no, like, Al's fine, like, we're just gonna take JJ to school. And I was like, okay. So I just got in the car, and then we went to Burger King because my little brother wanted breakfast, which was chicken fries for no reason.
Okay. I do dinner for breakfast all the time.
Breakfast for dinner and dinner for breakfast.
So, to kind of back up a little bit, so you had talked about your stepdad, when you put the bat out, your stepdad was coming towards your mom. Can you describe to me a little bit better kind of what was going on there? Like, is there a reason you put the bat up?
Yeah, he was walking towards my mom, and I just didn't want him to do anything, so I kind of just stuck out the bat. Like, my mom was right beside me, and he was right there, so it wasn't, like, between them.
Okay.
It was kind of just, like, I just stuck it out to be, like, keep your distance, kind of.
When you say you didn't want him to do anything, what did you think he was going to do?
Hit her.
Okay.
Yeah, it's, for the most part, been pretty, like, mundane, but there have been a few, like, violent times with him when I was really scared that he was gonna hit me or hit my mom, like, just because everything was kind of crazy. Me and him have always kind of not gotten along, like, just since I was little, And so there have been a few times that we've gotten in fights and stuff like that, and so so I'm just kind of always scared of that.
Yeah.
Yeah.
And then, so that happened, and he grabbed the bat from you.
Mm-hmm.
So kind of tell me that again real quick.
So I kind of stuck it out, and this is when he was like, if you hit me with that baseball bat, you're going to jail, and I didn't say anything, because I'm like, okay. And so I'm holding it by, like, the end of the bat, like, the place where you hold it, and so he kind of took it, and I kind of, like, lunged forward and kind of lost, like, my footing.
Mm-hmm.
And so my mom was like, just let go, and so, I kind of, like, slipped and I fell, kind of on, like, my side.
Okay.
Yeah, and then from that, my mom said to go to the car, so I just got up and ran out the door.
Okay, did you see, when you fell towards your side, did you see what he did with the bat?
No, I wasn't really looking in that direction, because from where I fell, the door was kind of more in my line of vision, because I fell looking this way and the door was like right there, so I didn't look back.
So he was at a different line of sight than what you were looking at?
Yeah.
Okay. And then at some point you saw him kind of take a step back, and from what you're saying, and tell me if I'm wrong or not, you didn't necessarily see your uncle pulling back, but it seems like that maybe...
It seems like he wouldn't have taken a step back on his own, so it's more of an assumption than anything. I didn't see him physically take him back.
And does that make sense based on where your uncle was at that time?
Yeah, he was behind him, because he wasn't on this side with me and my mom, so he was behind him.
Okay.
Because that's kind of just the order where everyone walked out.
And when that happened and then your mom told you to go, did you see what happened with your stepdad and uncle?
No.
Okay. And then once you went outside with your brother, you never came back inside?
Oh, I went to go get my mom's purse from inside so that we could have, like, her wallet and everything, but this was all happening, like I said, like, in the bigger room right here, and so I went through the garage door, and so the garage door is right here, and then there's like a little hallway, and then this is kind of where everything is, and then this is my mom's room. So when I went in, I kind of like just tuned everything out, ran to my mom's closet, ran back, so I didn't see anything, I didn't hear anything.
When did you go back in and get her purse?
After my mom came out.
Okay. So after you heard that loud noise?
Yeah.
Okay. And when you heard the loud noise, was your mom outside or inside?
I'm trying to think. I think she was inside when it happened, and the door opened like immediately after.
So very quickly after the door opened?
Yeah.
Okay.
So it wasn't like a long period of time, because I remember not like thinking about it for that long, and if my mom hadn't come out immediately, I would have, been thinking about it for a lot longer than I had.
So, obviously I don't know, like, your mom and stepdad and uncle, like you do, I don't. So, can you tell me kind of where the three of them were at, kind of emotionally, and how they were behaving when all this was happening?
When all this was happening, or like before?
When all this was happening. So like when you came out of your room and he took the bat from you and...
Yeah, so my stepdad was like, he was like, I don't even know how to explain it. He honestly just looked like kind of a crazy person.
Okay.
Like, screaming, and like his face was beet red. He just looked like really mad. I remember when he took the bat from me, I saw his face for like a split second, and I honestly, like, it didn't even look like him. He just looked like pure like rage. Like he was just seeing red. So I haven't really seen him like all the way like that before. That's like the craziest I've ever seen him. And then my uncle was kind of calm, like not super calm, obviously it was like a stressful situation, but he's like, I don't know, he was kind of just standing there in the doorway, kind of just being protective of my mom, but he wasn't yelling or really saying anything.
Okay.
And my mom was just he was yelling and my mom was kind of just like talking.
Okay.
So, yeah.
But you don't remember, if you do, like what your mom was saying at all, or what he was mad about?
No, not really. I'm sorry.
It's okay.
Honestly, like
we're talking about something that probably happened over 2 seconds of time. So.
Yeah, honestly, it feels like 2 seconds and 40 minutes at the same time.
Yeah.
So I don't remember what they were really saying. I just kind of heard yelling over everything. Mm-hmm. I don't know. I kind of just do that whenever things are like really loud. I kind of just like tune what people are saying out, because I don't know, just yelling isn't fun, obviously, for a kid to hear. And with my biological dad, I always heard him like screaming and stuff, so I kind of just learned how to like tune it out.
So when you woke up to yelling, and you had said you weren't sure what they were actually saying, did you know who was yelling when you heard the yelling?
Yeah, I knew it was my stepdad. Well, at first I kind of didn't. Like, when you first wake up, you're kind of disoriented. And then I remembered that my stepdad was, like, coming in to take my little brother to school today, so I immediately, like, knew it was him. Mm-hmm. And then my uncle I knew was staying, so I knew that was him. And then my mom, obviously, I knew that was her. Mm-hmm. Yeah.
And then, so you stepped out of your room and you took the bat with you. Is there a reason why you took the bat with you?
Honestly, I think that was kind of just like first instinct. Mm-hmm. Like, obviously I didn't ever hit him with the bat or anything like that. It was kind of just for like security, I guess, to know that I had it. I didn't do anything with it. In hindsight, I probably just shouldn't have brought it out at all because it caused more trouble. But it was kind of just first instinct, and it was right by my bed. So I kind of just like jumped up and grabbed it.
So I'm trying not to put like words in your mouth and stuff.
You're good.
So was there something in particular that you were concerned about that you would have taken the bat with you?
Only if he had been violent towards like me or my mom.
I'm assuming you're talking about your stepdad?
Yeah.
Okay. All right.
Yeah. But it wasn't like, oh, I'm going to take the bat and like do something with it. It was kind of just like, I need something in my hands to like feel safer.
Okay, that makes sense.
Yeah.
So my kind of second dumb question is, and I don't know that there necessarily is, but I always kind of want to make sure, is there anything that, we didn't talk about or I didn't ask you about, or anything that you think is important or anything that I should know? Because it's harder for you because you were there, and so I'm asking questions about something I didn't even see. So I just want to make sure like I didn't miss something or anything that you think I should know about.
That was pretty much it.
Okay. And if you think of something, in 5 minutes and tomorrow or whatever else, we can always talk again. It's totally fine. So I talked to your mom about we have some victim services people that work here. They're not cops. They're really good at what they do. So I really want your mom to talk to them because I think it would be good that your mom has, and you guys have maybe kind of some extra support if you need anything kind of go moving on. Mm-hmm. So I'm going to check in with your mom real quick, and if she's good to go, then I'm going to introduce one of them to you guys. That way you guys can talk before I take you guys back. Okay? Sound fair? Okay. Do you have any questions for me at all?
No.
Okay. If you do, let me know, okay? Okay.
All right, so that is Tylee after Charles was shot and killed. So, and I'm pretty sure that's what they're arguing today, that Lori wants this testimony to come in and the state does not. The state just wants to use what was the 911 call response. That's what the state wants to use, or he wants to have this come in, as well as her interview. So that's it. Yeah, it's a good question. Hey, Mona, how is it legal to talk to a minor without a guardian in the room? It's a good question. Good question. All right, so they are 30-minute delay. So they started at 25 after. So we got about another few minutes, just a few more minutes before it kicks in. And we have Joe Schmo is there. So we're waiting to hear from him. But remember, this is a 30-minute delay. So did the judge rule against it? Well, we just watched it. Hey, Mona, we literally just watched the one from last week. And let's see. Okay, so the state says, so the defendant has been found guilty of killing a witness. She can't bring her statement in for this trial. I guess, yeah, I'm still not 100% sure. I'll go with that. It's not going to come in. I'm pretty sure it's not going to come in, and I'm not sure if the judge is going to rule definitively or not, but the state did say that she can't bring that in. I thought she was talking about the two trials going together, but I guess that makes sense too. Yeah, I'm going to go with you're right. I don't know if he ruled against it though. I'm not 100% sure. I mean, for sake of argument, sure. To be quite honest, I don't know. I guess we'll find out today, one way or the other, whether he's already ruled on it or not. I don't remember him saying it last week because we just watched that, but I could be wrong. I don't know. So Nana Lori gave her permission to interview her. Okay. Ken says judge technically reserved on this ruling, but basically says it's probably out. Hey Mona, this case is so difficult. I wish they had just left her in Idaho and denied her the platform of attention. Well, we're definitely going to watch it because she's pro se and I just am all over this. Okay, let's see. We do have Joe Schmo there in the courtroom. Oh, good morning, Charmaine. I think that it is legal for them to interview a minor alone if they are considered the victim, but they need the parents if they are a suspect. That's good to know. Thank you for that. Irashimi says, I'm pretty sure he ruled that she couldn't use it because
some of the bigger issues such as pretrial publicity or opinions people may have had or exposure to the
Judge comes flying in hot. All right, hold on there. Hold your horses there, Judge. Flying in hot on me. All right, here we go.
case people may have had, and then it has the questions where we may lose additional jurors on the trial schedule, and then victims of crime, views about police officer, and then if they've been charged or close family members have been charged with a criminal offense, and to explain that. Any comments from the state?
Judge, in terms of publicity, I think my concern would be that when the jurors come in here and start hearing about the case or hearing testimony about the case, they'll hear the names Tylee and JJ, which obviously were there was more publicity about those than about Charles Vallow. And so I think if we really want to ensure that the jury is unbiased and has had no pretrial publicity with regards to the defendant, we're going to have to question them as to their knowledge of her other convictions out of Idaho. That was something that was just incredibly all over the media.
I agree, but I think that may happen in individual voir dire. This initial questionnaire, if they recognize the name Vallow or Daybell and they've been exposed to something in the media about it, they should tell us about what they know about it and about whether they know about that other case and whether they know about anything that happened to it about it. So I anticipate losing a number of jurors just based on that. But I agree with you. Some may say they've been exposed to it, but it wouldn't affect their ability to be fair. And in individual voir dire, we can explore those options. I don't want to necessarily taint the whole pool by saying, hey, she's got these convictions in this other state.
And Your Honor, I don't propose we talk about the convictions, but we will hear the names JJ and Tylee in this trial. So that's my concern, is if we don't raise those names, whether or not we put them in the list as people that they may hear.
What I could do is on question 15, where it lists out my name, the court staff, I need to include your name, the attorney's names, the advisory council's names in there. I'll add those. But at the bottom where it says other potential witnesses, is there any in addition to those two?
That would be the only for that. I think the other issue is, of course, the defendant's supplemental 15.2 names.
When was that filed? I haven't seen it.
I filed actually 2 motions to preclude them all and emailed them to your court Sunday.
Okay, maybe that's in my folder that's on my desk. Before we
filed that on the 12th of March.
Okay, before we get to that, let me ask the defendant. Other comments on the proposed questionnaire and the information that we're going to put in there?
I think it's
What's that?
pretty clear.
Okay, do you have any objection to listing Tylee and JJ because they will be mentioned?
No?
Okay. All right. Let's take a look here. Let me ask the state, you have 21 witnesses listed. I need to look at the defense witnesses that were listed. And we're after jury selection. I recognize jury selection could take longer than the initial week that I've set forth, but from April 7th to May 15th, the current screening, that is 20 full days of trial and 2 half days, so essentially 21 days of trial. Do you really think we need to screen that far out? I know you're being overly cautious.
I think, especially given that I'm not positive we'll pick a jury in that first week, I think we should, Your Honor.
All right. Defense have any comment on how we're screened through May 15th?
I think it's plenty of time, Your Honor, myself.
All right, let's deal with a couple things. First, I've received the notice of compliance. That was when the defendant requested the Gilbert video. Does that apply to the second case or this case?
Your Honor, it's an incident that occurred in January. It's not really, it was disclosed because it is mentioned in the DR. The defense had filed a motion for the state to disclose that, and then had brought up again on the 11th that the state had not disclosed it, that there was some YouTube video of that. I have looked for said YouTube video. I have gone through the police report. I don't know what video she's discussing, but we're not aware of any video that hasn't been disclosed. So I'm just providing notice that disclosure is complete as to that police report that is peripherally relevant.
All right. Any comment on that?
Yes, Your Honor. For clarity, is the state proposing that there is no video or that they don't have to give it to me because it's not attached to that DR number?
I think what she said was she's not aware of what video you referenced. So as far as her knowledge, she doesn't have it and doesn't know about it.
So I should go directly to Gilbert Police Department to get it?
Well, last time you were in court, you said your investigator or someone told you about it.
A mitigator.
A mitigator.
Showed it to me.
If they have that link, why don't they just send it to the state, and that may help the state determine if that's something they've already disclosed.
I will tell you why they won't, because that is my former team, and they will not do anything to help my investigator, my paralegal. They won't give us any information that they found. They won't talk to us at all because apparently there was a conflict. So they will not help us. They will not send us anything. They will not email us anything. They will not answer anything that we ask them to. So that has been the response from my former defense team. That's where we are.
All right. Do you know, and maybe your advisory councils can speak to this, did they turn over a file to you, or did you have to start from scratch?
No. From what I understand, all they turned over was the 22 terabyte hard drive, and that is it. They didn't turn on any notes, any work product, nothing that they had done to that point. Continue to stand by that today, even though a lot of that information I gave to them, they would not give it back to me.
All right. I'm going to make an order, and it'll be in the minute entry that they turn over a copy of their entire file, including any mitigation information that was gathered to the advisory council. To Ms. Hicks, you look like you want to say something.
I don't know.
You have to ask the attorney.
Right. No, I'm good, Your Honor. Thank you.
All right, so I'll do a more detailed order about, they should have turned over a copy of their entire file to advisory council when they withdrew. So I've read the defendant's disclosures that were filed March 6th and March 12th, as well as the state's motion to preclude. Well, let me start. Have you received any response from the defense, anyone from the defense team since you filed this on March 16th?
Your Honor, last night at 10:30 or so, defendant's investigator sent over a list of the addresses of the witnesses. I did speak with him this morning. I still am unclear if defense will be setting up those interviews or if they will be providing phone numbers to the state to set them up ourselves. As for the expert, again, last night at like 10:30 at night, defense investigator emailed the state and indicated that the defense expert would need to or wanted to obtain the physical laptops and cell phones that the police had impounded so that he could then review them, do his own sub-right or extractions. So obviously the expert hasn't even begun work, let alone, they've also requested all impounded items from law enforcement. I'm unclear if they're asking for ones that were impounded in Idaho as part of their investigation or just the ones here. The statements from the investigator appears to be all of them, which would mean the state would have to request Idaho to send those to the investigator. So again, given all of those issues, I don't see how that it would be possible for the state to provide that to the expert prior to this trial beginning, let alone to get a report or an opinion prior to this trial beginning.
All right, let's set aside Dworkin for the time being. So well, let me ask the investigator. What's your name, sir?
Jeff.
Jeff what?
White.
Okay, Mr. White, are you going to be setting up interviews for the state to interview whatever potential witnesses the defendants noticed?
I'm trying to verify, excuse me, sir. I'm trying to verify the phone numbers to be correct. I do have a few of them, but some of them I'm trying to make sure that these are the correct numbers.
Okay.
I did the searches for them, and I have to apologize. I left yesterday, and for some odd reason, my email just did not go through. So,
Your Honor, my understanding is that the state has interviewed every single person on my witness list previously. That's where I got the people from the interviews that they had from the state previously. So I understand that they're allowed to do another interview of them, but they have interviews of every single person that is on my list, with the exception of one.
Which is who?
Which is Nate Eaton.
Okay. When you say the state's done the interview, do you mean police or someone from the prosecutor's office?
In discovery, I have interviews with police on every single one of the witnesses that are on my list.
Okay.
So I know that they had their addresses. I know that we were trying to get the addresses to them in the quickest way possible. And where I am at the jail, the communication is very difficult for me to get a hold of my investigator, to get a hold of my paralegal. I'm 23 hours a day locked down. If I don't have Wi-Fi, I don't have a phone. If I don't have battery, I don't have a phone. I don't have access to get to people. So I understand the time constraints, and we're doing the best that we can of getting things answered, getting things put together.
So as a threshold question, your assertion is that all these people that you've listed in your notices have relevant information for trial?
Correct.
And do you know if the police have interviewed these people?
Your Honor, the first listed person is a reporter. So I'm not really sure the relevance of a reporter.
He's the only one that hasn't been. So that's what I stated.
So, Your Honor, the point is to start with, one, these people, I'm not sure all of them actually have been interviewed. Those that have would have been interviewed 5 years ago. So whether or not their addresses are correct, unclear.
It's not the state's responsibility for the defendant to do the defendant's work and find these people. I have an absolute right to do interviews just as the defendant does. So in terms of the witnesses, I think that most of them, as best I can guess, would be character evidence, which would be improper under 405. So depending on what they say, then I need to file motions to preclude or motions in limine for any or all of these witnesses.
All right, so it's premature to address these today. The state's going to have to interview them and find out if, in their opinion, they have relevant information or not. And then if there's a dispute as to whether or not they'd be called, I'll have to deal with that as it comes up. But if they're unable to be located or interviewed, obviously they won't be called at trial. Mr. Dworkin, if you want him to do extractions, you're not ready for trial. So in order for him to do the work that he's requesting, getting copies of a laptop or a cell phone or whatever the case may be, that's going to take him time to extract and analyze and then prepare a report, months maybe.
I understand that, Your Honor, and I'm hoping he can do it in an expedited manner. I requested him from OPDS on January 14th. He got approved on March 7th.
Well,
from OPDS.
You're the one pressing for your speedy trial, so you kind of have to make a decision on, we're set for trial, you want to go to trial or you want to have him do that work that you want? Because I don't think both are going to happen. Even if you got the laptops today, generally those types of things can take weeks, even months to analyze and prepare a report on.
I understand that, and I also understand that I've only been given 10 hours for him from OPDS, right? So if he could spend 10 hours this week getting them ready, then he can give us a report with the best that he can do.
Well, the report's already late, technically, but if it were allowed, first of all, it's going to take time to coordinate him getting the. Let's start here. Specifically, what are you requesting? Because the state wasn't clear whether you were requesting items here impounded by a particular police department or items that may be impounded in Idaho.
Well, I'm sure that my investigator would like to have all of those things done, and I realize that we're on a time constraint, and I would be only concerned with one item, which is at Chandler Police Department, which was Charles, my husband's phone, Charles Vallow's phone. And I would like a copy of the extraction that they took from it. The digital forensic extraction from Chandler Police could be given to him immediately. That would be very helpful.
Wasn't that already disclosed?
Yes, Your Honor.
Was that part of the initial terabyte?
Yes.
Excuse me.
Yeah.
Everything that I have is on a 22 terabyte hard drive. So if I give that away, I can't do my work.
Well, can't you make copies of files out of it?
22 terabytes.
I understand that.
Okay.
So what's your proposal?
I'll take it up.
I mean, if you have all that information in a file, I'm not saying you have to copy the whole 22 terabytes, but there's a file in there somewhere that's the Cellbrite extraction already for that requested item that's been in defense possession for however long now.
I'll take it up to Lonnie.
So I'm happy to make an order, but again, if he's not done with that information you want, are you still wanting to proceed to trial at the end of this month?
Yes, Your Honor.
Okay.
Do you know what's really fun? Making a website on Wix.
Hey, we're How Ridiculous, three childhood friends.
Depending on what his opinion is, first of all, it's late under the rules of evidence and rules of disclosure. And secondly, depending on what he says, the state would have to have an opportunity to consult with an expert as well. So even if he got something done, it could still be precluded, but I'll give him the opportunity to do whatever it is that you think he needs to do to analyze that. But that information's been in defense possession for months, if not over a year.
More than a year, Your Honor.
Yeah.
And he was just approved by OPDS last week, Your Honor.
I thought you said he was approved. You applied in January.
I applied for him in January, and last Friday, he got approved.
Again, this is one of those things where you have to weigh your options on whether it's worth it to get a continuance so you can have your defense do the work that you want done on your defense. But if you're telling me you don't want to do that.
I would like to do that, but my situation in my housing department precludes me from doing that.
From asking for a continuance?
No, from getting things done in an effective and quick manner.
Okay. All right, well, so you're telling me you don't want a continuance because any information he has at this point could be precluded as being untimely.
I understand that is the rule, and I understand how unfair and prejudicial that would be to me.
Okay. So I guess I'm going to have to cross the bridge on whether these notice defense witnesses are even able to be located and interviewed before I make a decision on whether they have relevant information and can be called at trial.
Obviously, Your Honor, we have a little over a week to try to interview these people, so I will file something at the end of next week indicating who I've been able to reach and interview and ask to preclude everyone else.
All right.
They also obviously ask to preclude them regardless, based upon what they may say.
All right. What else do we need to address today then?
Your Honor, the only other motion that we did not address last week was the State 609 motion. I presume the defendant will likely testify, so I don't know if we wanted to address that now.
Are you prepared to address that now?
No.
I generally will, I guess I'll advise the defendant now that if you choose to testify, it's likely that the jury would hear about the convictions. But at your request, they could be sanitized, meaning that they would only hear about the fact that you have convictions as opposed to what the nature of the conviction are. But that would be up to you whether you want that information out or not. And then the jury would receive a limiting instruction that the existence of those convictions is only to be used for the purposes of determining credibility. So you should be aware of that when you make a decision on whether you want to testify or not. Oh, if you do want to testify, it will be question and answer, meaning you need to write out all your questions that you want to be asked and have one of your advisory counsels ask those questions to you when you're on the witness stand.
Right.
Okay, so you can't take the witness stand and just give a narrative. It'll be question and answer.
So am I supposed to reply to the 609? Is that what you're saying? And ask for it to be sanitized if I want that?
We can talk about that when we actually have a 609 hearing, but yeah, you can make that request orally. You don't have to do a written response. I indicated last time for your opening statement and closing argument and questioning witnesses that you'll pretty much be limited to the podium. We'll be in a different courtroom apparently for trial, but it'll be set up very similarly. Either your investigator or one of your advisory counsels will approach witnesses with exhibits if you have to show a witness an exhibit. So I'll have to do the same limitations on the state. The state would be confined pretty much to the area of the podium, and the state would have someone assist in approaching witnesses with exhibits and that sort of thing. All right.
I have some motions that I'd like to file. I've had a really hard time getting my paralegals very busy. I don't have copies.
All right, we'll make copies and give them to the state, and then we'll file them, and depending on what they are, I'll rule on them as the response and replies come in, or we may have to address them depending on what they are. So plan on that questionnaire going out. I think we said, next Thursday, the 20th, will be sent out to potential jurors for the first batch of jurors, and then the responses would be cut off on the 26th.
Judge is going to be sent out Monday the 24th and will end on Monday the 27th.
All right. And then I'll meet with the parties on the 31st to go over those remote responses. So that'll be the 31st at 10:30 a.m. Then again, I'll just reiterate on April 1. Are we having we're not having walk-ins, Izzy, until the 1st?
Correct.
Okay, and then on the 1st, we will meet again, and for the rest of that week, we'll likely be meeting at 10:30 and continuing with jury selection every day until we get enough jurors. Hopefully we get enough the first week. If we have to, we'll go into the second week.
Yeah.
Judge, I know that I'd given you a date that I was going to need to be dark on. I'm going to put out there, since I obviously don't know when we will get the jury picked. I do have some witnesses that are flying in, so I may have some days where I may need to end a little early or whatnot to try to accommodate some witness schedules. But I'll keep the court updated once we get a jury picked.
I think we'll have a good idea by about day 2 of jury selection whether we're going to need to go into the next week or not. That reminds me, though, is I would like the parties to plan on, we're going to have a much better idea after about the second week of trial and the first trial, how the second trial will unfold as far as how many jurors we might need. But I would like the parties to plan on doing another remote questionnaire with a much larger pool for the second trial and meeting on Friday, May 30th. I'm just giving you a heads up as far as this is concerned. And then for scheduling purposes, so everyone knows, I'm planning on probably going Monday through Friday of the week of June 2nd, as well as Monday through Friday the week of June 9th, to try to get as much done as we can. And then there's going to be some dark days there toward the end of June, but we need to get it done by July 4th.
Your Honor, when are you planning on starting that trial?
So jury selection would be starting May 30th. All right, anything else from the state for today? If you want to stick around, we'll get you copies of those motions.
I do. Your Honor, I guess the only other thing is, for the questionnaire, are we going to put in the defendant's 15.2 witness list?
I'll put in those names preliminarily. It doesn't hurt, just in case anyone is called from that list. And if anyone knows any of those people, I will put that in, actually. Anything else from the defense?
So I'm unclear on where we stand with the video that I requested.
The state says they don't know what video you're talking about. They've disclosed everything they have. So I'm going to make an order to your prior team to give you whatever that is. If you have a link in that information, you can forward it to the state so the state can see if that's something they've already disclosed or if that's something Gilbert didn't give them, or on the other hand, since it was told to you secondhand or showed to you secondhand, whether it's something different than what you thought it was. I don't know. So I'll make an order that they hand over all those things to you, so maybe you can figure that out. But at this point, the state says they've disclosed everything that they have and everything that they're aware of.
And in that order, they'll give it to my advisory council, or who?
Who do you want me to? I was going to say give it to your advisory council. Do Do you want a more narrowed order? Maybe any mitigation work that was collected, or do you want a broad order that's basically everything in their possession?
Well, it would be nice if they could turn over everything in their possession that we worked on.
I was just thinking
together.
it would be easier for you maybe to find that needle in a haystack if it was a more narrow order.
Well, she knows what the link is, and she could just give it to us, and we asked for her to do that, and
What's that?
the attorney said, no, she can't do that. She can't give you any.
What's that mitigator's name?
My mitigator's name? Pamela.
On your prior.
Pamela Kearney.
Do you know how do you spell Kearney?
Cerny.
All right, I'll make a specific reference to that.
And do we need an order, Your Honor, to pick up my husband's phone at Chandler Police so that Lonnie can do the extraction?
Well, you already have that extraction in your discovery. What's the state's position on Lonnie Dworkin meeting someone at, you said Chandler, right? Chandler
Yes, at
Police
Chandler Police
Department to do another extraction.
Your Honor, obviously the state and defense have always had stipulations so that should something happen to the device while it's in the possession of Mr. Dworkin, that there are now no issues with chain of custody or anything else. So the state would have to draw up a release, have that scheduled on who it's going to be picking it up, have the defendant sign that release indicating that she understands that should anything happen to that she waives those rights to claim those things. So
I think what I was asking was, does Mr. Dworkin have the ability to just do the extraction on site?
on site where? At Chandler?
At Chandler.
I don't think the police departments allow anyone to go in there and conduct their work in the police department.
Okay. All right, so to maintain the chain of custody, the state can draw up an agreement, and if the defendant signs that agreement, then Mr. Dworkin could pick up that phone.
That's perfect. Logistically, how's that going to happen?
She's going to forward that to your investigator, and I guess he'll have to come down and have you sign it.
Okay.
All right. Be at recess.
All right, so that is that. We will go over what happened. Let's see. Okay, so the state talks about publicity concerns, that she's sure the jury will hear about JJ and Tylee, because there's more about them that's out there than Charles. Not to diminish Charles, but JJ and Tylee got a lot of press, as you may or may not know. And Charles has gotten some, but not as much as JJ and Tylee. So that's what the state's concerned about. Let's see. We're going to have to question Lori about the Idaho conviction. That's state saying that. The judge agrees. I'm sorry. Yeah. Okay. So then the judge agrees, but that may happen in voir dire. So there's no objection to listing Tylee and JJ on the questionnaire. The state is planning on calling 21 witnesses. They were talking about April 7th to May 15th. Do we need to screen that far out? The judge asks. So state isn't confident it will take only 1 week for jury selection, but Lori is confident. Then she talks about the Gilbert police review. The state couldn't find that YouTube video. Lori is saying, is the state saying that they can't find it or it's not out there? Because we know it's out there because we watched it. At least we watched something. Lori says the mitigator showed it to her and the former team won't help her because apparently there was a conflict. They're not answering her emails or her phone calls or anything about that. Then they bring in the 22 terabits. So apparently there's 22 terabits of information out there, whether it's a hard drive. I don't know. I guess it's a hard drive. I'm not sure if it's on disks or it's in the cloud. I guess it's on a hard drive. I think it's on a hard drive. So she says that's the only thing her previous team turned over. So she's saying they didn't turn over any paperwork or anything like that. They just turned over this digital information. Boom, here you go. The judge is going to look into that, as they should have turned over everything when they withdrew. So then last night at 10:30 p.m., The state says the defendant's investigator sent over a list of witnesses that are going to be interviewed. The investigator emailed last night wanting to obtain physical laptops. He wants those to be impounded. The state's saying that the expert hasn't even begun any of this work. So all impounded items are from law enforcement. Or so do they want the ones from Idaho or the ones from just here? The investigator seems to want all items. And then the judge said, let's set aside, I think, Durkin, something like that. And then Jeff White, so that was the expert. So then Jeff White is the... So then Jeff White is the investigator. He was there. So he's looking to verify phone numbers for the interviews he needs to set up. So Lori understands the state has interviewed everyone on her list except one. And guess who that was? Nate Eaton. And the state was like, and he's just a reporter. Oh, poor Nate. No, Nate, you're more than just a reporter to us. Lori says, communication is difficult in my jail with 23-hour lockdown. Let's see, anybody, hold on. So Lori understands the state interviewed. Okay, everyone has relevant info for this trial. State doesn't see the relevance of a reporter. Oh, Nate. It's the first witness on our list. Yeah. Nate, you're important to us. If you're watching, you are important to us. It's not the state's responsibility to find the defense witnesses and interview them. Fair point. If you want Dworkin to do the extraction, this will not be ready for trial. The judge is saying it takes months to do this extraction, write reports. Lori requested this in January. He got approved in March. I'm hoping he can do this in an expeditious manner. The judge says, you're the only one pushing for a speedy trial. So she has to make a decision, speedy trial or continuance. She wants to do speedy trial. But Lori has only been given 10 hours. This guy, Dworkin, has only been given 10 hours. So the judge says the report is already late technically. So he asked specifically, what are you requesting? And she says, my expert wants everything, but specifically wants Charles's phone. If the investigator gives over the hard drive, he can't do his work, right? So the judge is like, can't you just copy certain files? And the investigator kind of grumbled. Lori still wants to proceed. She doesn't want to do a continuance. The state has a little over a week to interview everyone, so that's 21 witnesses. Probably not going to happen. Then they talk about the 609, which is the defendant. The state says the defendant is likely to testify. So the judge asked, do you want to talk about that now to Lori? And she's like, nope. If you do testify, the jury will definitely hear about your past convictions. The judge says there will be a question and answer, and advisory counsel will ask. Oh, this was, okay, so if she does testify, it's going to be question and answer. She's not going to just get up there and do a narrative. So thank God for that. Although I kind of do want to just see her get up there and do a narrative. I think that would be fun, but judge says no to that. It's going to be a different courtroom. We heard that. There's going to be a different courtroom, but you're still limited to the podium, so there will be more room. Counsel will have to run evidence to and from witnesses. And then Lori has some motions to file, but she doesn't have copies, so she gave that to the court to file the motions. Jury questionnaire is going to go out the 24th, which is next Monday, or this coming Monday. Yeah, a couple days from now, next Monday. April 1st is going to be a jury selection. It's going to start at 10:30. Lori raises her hand, but then nothing happens after that. State is dark on certain days because they have people coming and going. The judge says we'll have a good idea within the first week of the first trial to see where they stand with the second trial. And I saw some of you asking, and I think you guys kind of sorted it out. The first one is with Charles Vallow. The second is with Brandon Boudreau, who is her niece's ex-husband that he was shot at. So those are the two trials. Let's see, Monday through Friday, June 2nd through the 9th, they're going to try to get as much done as possible. May 30th is going to be trial number 2. Lori asked, but what about the video? Judge says the state doesn't know what you're talking about, so he's going to make an order for them to hand everything over and you can figure it out. She wants law enforcement to get Charles's phone to Dworkin so he can do the extraction. And the judge is like, can Dworkin do the extraction on site? And state's like, I don't think law enforcement will allow that. So, all right. So there we are. We have Monica coming up, guys. Let's get over to Monica, right? I'm going to... let's get over to Monica. All right, so I'm going to end this stream. Thank you guys for watching. Thank you to Aaron. Thank you to all of our fantastic mods. Thank you, chat, for hanging with us. We're going to go over to Monica now. All right, so hang on. We're going to portal you guys over. Thanks for watching, and we'll see you later. See you at Monica.